Okay. Okay. If everybody could please take your seats, we're going to move into the next panel. Ready or not? She's ready. Let's get her done. Yeah, the NASCAR joke always brings the house down. Okay, the next panel is called Identifying and Improving System Weaknesses in Criminal Justice. And we're turning complete control of the conference now over to the National Institute of Justice. This is a white-knuckle moment for us at the Quattrone Center. NIJ is the Research, Development, and Evaluation Agency of the U.S. Department of Justice, and they're going to discuss their groundbreaking and innovative Sentinel Event Initiative, or SEI, which is actively seeking to apply some of the lessons we've learned about the systems approach to the criminal justice system. To describe the program and introduce the panelists, it's my great pleasure to introduce Maureen McGough, a policy advisor in the NIJ Office of the Director. Maureen is a member of the Sentinel Events Initiative team and focuses on the identification and facilitation of internal and external partnerships. She also co-manages NIJ's Human Trafficking Research Portfolio, and those are four words that I never really thought I'd say right together. Maureen joined the federal government through the Presidential Management Fellowship, during which she managed federal AIDS relief efforts at the U.S. Embassy in Kigali, Rwanda, and served as a Special Assistant U.S. Attorney at the U.S. Attorney's Office in the District of Columbia. She has a BA from Catholic University of America and a JD from my alma mater, the George Washington University Law School. And Maureen, please take it away.
First and foremost, thank you so much to John and to the Quattrone Center for pulling together such a thought-provoking symposium, and also for generously giving us a space on your agenda to discuss the Sentinel Events Initiative. I am honored today to be joined by the people on this panel. First and foremost, Jim Doyle. Jim is a distinguished defense attorney out of Boston who is a recent executive fellow at the National Institute of Justice. His fellowship actually just ended, and we miss him already. Basically, Jim is the godfather of the Sentinel Events Initiative, if you will. He came to NIJ with the idea that an all-stakeholder, non-blaming, forward-looking review of sentinel events in the criminal justice system, like wrongful convictions, wrongful releases, or even near misses, that draws heavily on the work that NTSB and the medical field already do, might actually have the power to transform the criminal justice system as a whole and really change the way that we do business. And Jim, if this works the way that we think it might, NIJ and the criminal justice system are definitely in your debt. And if it doesn't work, it was Jim's idea and he's no longer associated with the National Institute of Justice. And as you might imagine, when you think about conducting this type of review, I'm sure you can think of dozens of partners that would be helpful to have at the table. But I would guess that maybe the first three, or towards the top of your list, would be law enforcement, prosecution, and defense. And that's what the rest of our panel represents here today. Maddie DeLone is the executive director of the Innocence Project, and she has generously contributed early and often to the way that we think about the Sentinel Events Initiative at NIJ. She was an integral part of an expert working group we hosted last May to really explore how this system might work in practice. Sean Smoot is the director of the Police Benevolent and Protective Association of Illinois. Sean, like Maddie, has contributed greatly his wisdom to the development of SEI at NIJ. He was also at that expert working group, so let Sean and Maddie be a lesson to you all that when NIJ invites you for a 2-day working group, we're going to be using you for years afterwards to talk about the exact same stuff. And last but certainly not least is John Chisholm, and he is the district attorney of Milwaukee County. When you talk about doing system reviews in the criminal justice field, Milwaukee is really writing the book on this, due in large part to John's leadership. And NIJ is very excited. We're going to be working very closely with Milwaukee as the Sentinel Event Initiative develops. I'm going to talk to you just a little bit about SEI and what NIJ's interest in the Sentinel Events Initiative is, and then turn it over to Jim Doyle for a much more robust discussion. Basically, the Sentinel Events Initiative is a research program designed to examine whether this type of learning from error review can actually be implemented in the criminal justice system. We've heard a lot about the similar themes over the last day and a half. Obviously, it's very exciting. It seems very promising, but it also raises a lot of questions. So the three research questions that NIJ is focused on right now is, can this type of review even be implemented in the criminal justice system? If we do implement it, will it actually make a difference? And even if we are able to implement it and it makes a difference, is it the kind of change that's actually sustainable? Because that's really where you're going to get the results that you need. And NIJ is thrilled to announce that the very first phase of this exploration has begun as of late last week, I think. Through a very rigorous application process, NIJ was able to engage with 3 different jurisdictions. We're actually calling them beta sites, and I don't know if you caught that Mr. Hart from the NTSB yesterday said we needed beta explorations. I would say we know and we agree. So that was great that he acknowledged that. And these beta sites have self-identified sentinel events in their jurisdiction that they have brought a team of stakeholders together to conduct a review, and they will be planning and conducting that review through 2014 with some technical assistance from the National Institute of Justice. As I alluded to earlier, John Chisholm and his team out of Milwaukee will be one of our beta sites. Also very pleased to say that Philadelphia is going to be one of our beta jurisdictions, and the Quattrone Center and John Holloway will be imperative partners in that review process. And in case anyone's wondering, Baltimore is going to be our 3rd site. So with that, I'm happy to turn it over to Jim Doyle for a discussion of the Sentinel Events Initiative.
Thank you, Maureen, and of course, thank you to the Quattrones, the Quattrone Center, and to John for inviting me to talk here. The challenge at this point in a conference that has been this terrific, the first conference I've attended in about 40 years of conference going, where I actually attended the whole conference. Couldn't find the time to go out and take a walk or have a drink or get coffee. The challenge now is to say, well, what hasn't been covered by people who've spoken before? And the answer is we haven't talked about me. People find that a very interesting subject, and particularly in the context of what Maureen just said, people are asking themselves, how is it that a broken down public defender like this gets his snout in the federal trough and becomes a visiting fellow? And the answer is, I wrote an article years ago. I began it with an epigraph from Lucian Leap. The body of the article was taken from Lucian Leap, and I changed all of the nouns from medical nouns to criminal justice nouns. And since then, we've taken a lot more from the medical people, and in a lot of ways, it's fair enough, because the medical people in turn took it from the safety people, the human factors people, the people who study huge tragic events like Chernobyl, the Challenger launch decision. And one of the key things that we've been taking and using as a guidepost of ours that's a little bit different from what other people have spoken about over the last day is a kind of etiology of error. How do things go wrong in the criminal justice system? And what we got from medicine was a series of studies of cases where medicine, rather than arresting and convicting the wrong man, operated on the wrong patient. And when they studied, I'm thinking of one particular study by Dr. Casson and his colleagues, what went wrong here? Why did we operate on the wrong patient? And gave it a close, detailed look. They found that there wasn't just one mistake. There were 17 mistakes. There were 17 mistakes of different kinds. There were little errors by physicians who didn't introduce themselves. There were little errors on charts that weren't corrected. There were structural errors within the hospital where the computer systems in the hospital didn't talk to each other, where they didn't communicate, where no one knew what was going on. And there were cultural problems where when something went a little wrong, nobody involved in the treatment of this patient saw this as a harbinger of disaster or a red flag, but saw it as just another recurrence of the everyday screw-ups that everybody had learned to live with and adopt to as time went on. But the key thing for the medical people was that of these 18 errors, no one would have been enough by itself to cause the wrong patient's surgery. And that's an idea that we think translates pretty directly into what happens when we have a wrongful conviction or other criminal justice adverse event. How do you convict the wrong man? Well, yes, the witness does have to identify the wrong person. So the witness made a mistake. But the police had to put the witness in the array. The police had to construct the array. The police had to find the guy and get him there in the first place. Things on the crime scene may have been overlooked, or if they weren't overlooked, may have been mishandled or misexpressed in the courtroom. The defense lawyers didn't find the mistake, the prosecutor didn't find the mistake, the grand jury didn't find the mistake, the appellate courts didn't find the mistake. The right answer to the question, who's responsible for this wrongful conviction, is usually everyone involved to one degree or another. If not by making a mistake, by failing to catch somebody else's mistake. And in this context, everyone involved doesn't mean just the people at the sharp end who made the immediate decisions that we tend to talk about. It means the legislators, the funders, the trainers, the supervisors, the people who do the hiring, often people far from the scene of the actual event who have created the working conditions for the people at the sharp end. And what that did for us was to say, I say us, I'm a former visiting fellow at NIJ, so I'm allowed now to tell you the truth about things that only a week ago I would have had to dissemble about. What it meant was that two of the common responses to criminal justice error were undermined by this recognition that when these things go wrong, they're not single cause events, they're organizational accidents, where individual mistakes cascade, where they combine with latent system weaknesses, and then, but only then, do you get to the result that you would like to avoid in the future. The first approach that was undermined is the approach that many of us feel when we hear these horrific tales of wrongfully accused people, where it's easy to see a villain in the beginning, where we can say, we have a bad apple detective here, we have a bad apple prosecutor who didn't turn over Brady material, to find that person and to punish them. What the organizational accident conception does is to suggest that that's an inadequate approach. It doesn't really explain what happened, because standing to the left and the right of the bad apple are the people who hired him, the people who supervised him, the people who created the incentives in his position, and on the other side, the people who didn't catch the mistakes, who weren't aware of the mistakes, and far away from all of those people who we think of immediately as being right in the line, a whole environment that's creating the choices that these people are making, creating downsides for these choices, creating incentives for these choices. So the bad apple approach doesn't adequately explain what happened, and it also has a destructive undertow, because if you're devoting yourself entirely to disciplining the bad cop, the bad prosecutor, the drunken, sleepy defense lawyer, or the corrupt judge, you can whack that mole. I'm all in favor of whacking that mole hard, but once you've whacked him, the conditions that led to his decision are still there. You haven't gotten at the underlying root causes if what you're going to do is concentrate solely on the bad apple. Another approach that we take is to find a single component, to look at a structural element of the process, and to think, if we could just repair this element, then we could prevent this happening in the future. So it's possible to get people to say, well, we have a criminal justice system here, but what they usually mean when you talk to them about a system is something that looks like a kind of folk version of this famous Swiss cheese diagram that a human factors expert named James Reason put together. So we have these cross sections where you have the police screen, you have the prosecution screen, you have the grand jury screen, you have the defense screen. They're all in a row, and you have this error that's moving in one direction from one side to the other, and if there's a hole in the police screen, and it lines up with a hole in the grand jury screen, and that happens to line up with a hole in the defense screen, only then does this error go through and take effect. The problem with this approach is that it's not really a situation where you have independent screens. All of these screens are acting on each other. It's true that it's easy to see how things that the police leave out are things that are going to have an impact on the prosecutor. But it's also true that lots of things that the police do and don't do, they do in an anticipation of what the downstream actors are going to want and expect from them. The relationships between these screens move not just in one direction, but in two directions. And they don't act in their own isolation. they're all acted on by their encompassing environment. And so the version of error, the version of the problem that we've been working on is not the Swiss cheese diagram where you have these cross sections. It's the diagram that Chris Hart put up yesterday, this very complicated Venn diagram of all of these overlapping circles, influences, factors, things that are all working on it. It's a very difficult and complex situation that can't be reduced to single structural elements. The strategy of fixing a particular structure is incomplete because the minute you try that, you're influenced by the other elements in the system. I'll just take one example that came up this morning that indicates why you want to think in systemic terms rather than these individual structures. There's a disagreement about whether double-blind sequential lineups are better than the traditional simultaneous lineup. The differences come from a differential in the number of false positives that you get from one versus the number of false negatives you get. There's a trade-off. But you can't really say which of these is better unless you stop and think, what's the rest of the system going to do with these results that you're generating? It's like looking at a monography. If the screening is too sensitive or the screening is not sensitive enough, you're going to have to say, well, what are the police going to do with this too sensitive screening? Do they have the resources to double check this, to rule this out, or not? Are false positives more damaging to the system as system than false negatives? One example of a way that thinking this way is more important. The problem with seeing these things as structures is that, and I don't want to make it seem as though this is something that this sentinel event approach is trying to wipe out. Plainly, these things are good and they're helpful, but they need to be complemented. To have a new checklist or to have a new method of doing photo displays is not going to be enough. The safety people would argue for a couple of reasons. One of them being, the safety people would say, there's nothing more dangerous to system safety than the complacency that sets in the moment after a system thinks a problem is solved. If, as Fran was saying this morning, you can issue a new policy or a new set of guidelines or a new set of checklists and think you're done, you're mistaken. The safety people would say that the minute you do that, the minute you get your new policy, the minute you get your new checklist out there, it's under immediate assault from its environment. It's under immediate pressure. You put your checklist out there and you put it in the field, and the people at the sharp end are immediately in a world of triage and workarounds. And if all you do is put that out there, then your checklist looks like nothing more than another disciplinary tool. The boss has given us a checklist. He's given us a 25-step checklist. We've got time to do 10 pieces of this checklist. And all this checklist means is that we have to guess which 10 we're going to do, and if something goes wrong later, then the boss can whack us for not having filled the whole 25 things in the checklist. This is the same boss who didn't give us the resources to be able to do it 25 times. And so your new solution, your new policy starts to be seen by the people in the front lines as one more disciplinary thing to be avoided. So what needs to be done here is to make some progress towards what Susan Silby was talking about yesterday, trying to find some way to have a system that over time changes its culture. You can't discipline yourself out of these problems by whacking the mole because the mole's incentives are still there. You can't design your way out of these problems because no design is perfect and any design is going to be challenged. So you have to think about it in terms of culture. And as Dr. Silby said yesterday, what you want to try to do is to find some way that over time you can change the culture to one that's working on continuous quality improvement. Not one that lurches from fix, which will have a shelf life and then be undermined, to fix, which in turn will have a shelf life and be undermined, or have some anticipated consequence some other place in the system. But to work continuously on doing this and doing it together. So that's what this Sentinel Events approach to looking at errors when we find them is meant to do. It's not meant to be a solution. It's meant to be a device that helps us move towards changing the culture to one where everybody is participating in making sure that we're getting better in the future, to making sure that we can pivot from blame for past events to cutting the risk of doing the same thing in the future. And we think it's important to try to get this going because it introduces a new kind of gravitational pull to sort of counteract two things that are very built into the way people think about improving the system. And I don't mean the way the bad people or the troglodytes think about improving the system. I mean the way the good people think about doing it. One is, I go to a lot of meetings like this, I listen to people talk, people will say, yes, you're right, we need systems improvements, but there's a gravitational pull back into their own stovepipe. Not for bad reasons, for reasons that are kind of admirable. Police who see this, see the need for change, will say, I see the need for change, we're going to start with us. We're going to pick our own mess and we're going to clean up our own mess first, so that everyone feels this pull back into their own local area. The second thing that happens is that even the really good people tend to think in terms of produce a product, come up with a new checklist, come up with a new policy. This is very woven into the way organizations work. It's woven into the business of grant giving, grant making, grant seeking, that the reformers on the cutting edge are trying to get themselves involved in. And the problem with that is, if all you're doing is producing your product and going away, thinking the problem is solved, it's an illusion, because this problem is not solved. None of these problems are solved. What you need to do is try to create a situation where everyone is continuously working on these things and not thinking of solutions as solutions. So, the idea here is to convene all the stakeholders. And by all the stakeholders, I don't mean all of the usual suspects like the people here, but in the case of a wrongful conviction, for example, the exoneree, the victim who wrongly identified the exoneree, the family of the exoneree. Other people should be involved in this. When I say all stakeholders, I mean all stakeholders. I don't mean the people who are just the usual people who might take the blame for this otherwise. I mean unconventional stakeholders like the Quattrone Center and its allied scholars who can take part in reviewing these events and consider how they can bring to bear on these events the knowledge from within their disciplines, the experience within the hospital here at Penn, the experience within the sociology department, the criminology department, the experience generated by the empirical legal studies that go on here at Penn, and bring those to bear on these events. This is not, I think, just a question of substituting a pile of anecdotes for a pile of statistical probabilistic findings, right? It is true that the methods of social science, of science in general, will involve picking something to vary while controlling for everything else and coming up with a statistical or probabilistic result, which will be true 80% of the time, but doesn't interface easily with a system where the goal is diagnostic, where the goal is not what happens 80% of the time, but is this one of the 80 or is this one of the 20? And so what we're hoping that this Sentinel Event Initiative can begin to explore is whether there's a way, by beginning to make this a routine practice, you can find a way to hold the statistical and probabilistic findings in tension with the individual narratives of individual events, so that we're neither just compiling anecdotes and sad stories, nor coming up with purely statistical events and best practices and solutions that are immediately going to be subject to undermining by the environment, by the impact of the other actors in the system, and to start to take advantage of some of the things that were spoken about by the aviation people and the medical people yesterday. One of the things that I think could happen is that you can begin by doing this Sentinel event work on a regular basis to pick up some weak signals from things that you wouldn't otherwise hear anything about. Things that don't manifest themselves as big across-the-board statistical problems, but things that are nevertheless worth studying that can be surfaced by all stakeholders looking at these problems rather than just looking from 30,000 feet down. I think there's also a question of how these things are done. Is who's there? Everybody's there. Everybody you can think of. Certainly the main players affected, but also the people from the disciplines who are involved. What are you going to do with this thing when you have it? Well, I think you can disseminate the lessons if you can find a good format to disseminate it. How is it going to be done? Where is it going to be done? It's not going to be an NTSB federal mandate where everything that happens will then be sent out, examined. But the hypothesis is that although it's not true that everyone everywhere will do this all the time, it may be true that you get a lot done if some people in some places are doing this some of the time. What events? We've taken the approach of allowing people in these beta sites to choose their own events. And I think that that's a good way to think about it at the beginning. To do this voluntarily, to say that we recognize that we learn different things when we're looking at events we want to learn from, not just at events that we're compelled to study because it's blown up on the front page of the newspaper. And so we're encouraging people to look at low-profile, repetitive events, near misses, the case where there's an eyewitness identified on the scene the night of the crime, the DNA comes back from the lab, wrong guy 6 weeks later. Because as John said, you want to get the right guy in the right way, but you also want to get him fast before he can hurt anybody else. And so those things, smaller events like near misses where someone has made a good catch and found a mistake before it can take effect, are things that can be very, very hopeful. Now, one of the things I've done, my job has been to go out and talk to people, see what they think about this. And the news I bring back from this is everybody is very much in favor of this idea. Everybody thinks it's a very worthwhile thing to do. Not everybody thinks it can be done. And nobody thinks it's going to be easy to do it. So that's why it's very important to have the cooperation of these beta sites involved. But we're hopeful that we can try to get something going here where we can begin to establish some general template that's nationally shared but enacted locally to look as a matter of routine at these events, to understand the perspective of all stakeholders, and to find a way to pivot from blaming people for something that just happened in the past to looking at the risk of what might happen in the future and trying to deal with it that way. Thank you.
Thank you, Jim. We're now going to hear from Sean Smoot, who's going to talk a little bit about whether there actually is a need for this type of review, if it's feasible, what are some of the challenges and how those challenges might be overcome. Sean?
Well, thank you very much, and I would also like to thank the National Institute of Justice and the Quattrones, and John, thank you for giving me the opportunity to address this distinguished group. I'm not sure and by the way, don't be insulted, please, by my keeping my seat. I took a poll of the other panelists, and they all decided before we started that we'd all prefer to sit, since none of us prepared PowerPoint presentations, because Jim told us not to. I am very honored to be part of this inaugural symposium and speak on behalf of the folks that I represent, which are police officers across the state of Illinois and across the country. I think this is an extremely fruitful discussion, and I think that there's a lot of potential to Sentinel event reviews. It's a tricky thing, and I kind of need to go back to a question that was asked after the last panel, because I don't know that there's enough understanding, frankly, of from the standpoint of the police officer, when people question, and even I question sometimes, why can't we just make these changes quickly? Why is there resistance to change? Why would there even be resistance to participating in a Sentinel event review like we do in medicine? And there's a couple of reasons for that. One, I think people need to recognize that, as police officers, you're trained to be hyper vigilant all the time. And that's just in the performance of your duties. If you're walking up to a car, you're trained to be suspicious, you're trained to be prepared, because you don't know what's going to happen when you walk up to that car. And we really ingrain that training into new officers when they go into the academy, and we continue it on. And then, unfortunately, we see examples of what happens when an officer sometimes is not careful when they approach a car, or when they walk into a domestic violence situation, and we have one of those big police funerals where there's, cars, squad cars for miles. And that's a constant reminder for law enforcement. What happens when you let your guard down? So you combine that kind of tactical mentality with the fact that anytime a police officer is involved in a critical incident in the scope of their duties, they already will face at least 2, probably 3, and maybe 4 different levels or types of review. So initially, take a police shooting as an example. If a police officer uses his firearm in use of force, that officer's conduct will immediately be evaluated by a criminal investigation, by a local prosecutor, who will make a decision whether or not the officer's use of force met the standards to be justifiable under the law. That will happen in some jurisdictions, within minutes, hours, maybe 1 day, maybe 2 days. Then they're going to, and if that, if that review finds the officer acted justified, actions were justified under the criminal law, now they're going to be investigated in an administrative investigation, which is more geared towards, did they follow the policy? Yes, their use of force may have been justified, but was it the right thing to do? And should they be disciplined? So now they're facing an interview or interrogation situation where they're called in by their own department or another department that's been asked to come in and conduct the investigation, and they're ordered under threat of being fired to answer questions about their conduct in this shooting. And, the whole point of the administrative interview or interrogation is to make an evidentiary case against the officer for misconduct charges. So they're going to go through that procedure. And, most police departments, unfortunately, have adopted and continue the practice of punishment-based discipline. The system is not really compatible, frankly, with Sentinel Events Initiative type of review. The punishment-based discipline is really, interested in placing blame, as we heard about yesterday and from the Police Foundation, punishing for policy violations. Where Sentinel Events isn't really interested in blaming, we're interested in fixing whatever's wrong with the system so that the same mistake doesn't happen again and again and again. And so that's the second. We're not done yet, because then there's also going to be, in some cases, a civilian review board, and certainly in almost every case, there's going to be a civil lawsuit. And that's going to then put the officer under the microscope for as long as that goes on. That might be the end of it, but it also might not, because the Department of Justice might decide later on to come in and review the criminal investigation, the administrative investigation, and whatever happened in the civil lawsuit. So if you wonder why police officers, when you talk to them about a different kind of investigation or a different kind of review of their conduct, why they might seem like long-tailed cats in a room full of rocking chairs, that's why. Now, that's not to say that officers lack interest in learning from their mistakes, because they do. I like other people have stated, I don't know a police officer that got into policing because they wanted to do the wrong thing. And if you ask people why they join the police force, if you ask people when you're interviewing potential candidates why they want to be policemen, it's because they want to help people. It's not because they want to put people away. It's not because they have an agenda against a certain group of people or another. I mean, I think for the most part we've gotten good at the screening process and that, but by and large, everyone that comes into this profession comes into it because they want to do the right thing. They want to be the hero. They want to be the person that does good and makes a difference. And so they don't see a review process as being, necessarily a significant issue. So if you asked a new hire, would this be something? Oh, of course. After they've been a police officer for a couple of years and they've seen the colleagues go through these multiple levels of investigation and review, and in a vast majority of these cases, officers conduct themselves in a way that's not only legal but also appropriate given the circumstances. You can see why they're going to view something like another layer of investigation through a modified lens. And so I hope that gives at least some people some insight into kind of the psyche that you're dealing with. It's not just so much that they don't like change. It's that, we have ingrained in them through their training and tactical training and then their observations in working in a police department environment from a human resource standpoint, this cause to feel, well, maybe, just because everybody's out to get you doesn't mean you're paranoid. That's, a lot of times I think when you look at everything these folks have going on, it's not hard to understand why they might be resistant. So I guess my point is, in addition to giving you that kind of background, we've identified things that we view as challenges to implementing a Sentinel events type of review. And, one of those is, if the Sentinel event review approach is viewed as simply another criminal, internal affairs, or civil review, it's not going to work because the people who are going to be involved in the review process are not going to feel safe. They're not going to feel safe to be open. They're not going to feel safe to actually say, wait a second. Knew she was wrong. And so I think that's really the crux of where we are. And Dr. Leap said it yesterday, and I thought, I wrote it down. So people must be part of the solution, or they will continue to be part of the problem. And what Jim said is absolutely right. You can't discipline your way out of this. You can't. If you really want to get to the systemic problems, and you really want to solve those, you have to bring in everybody. And how many times have we heard that from people who are a lot smarter and more qualified to talk about it than I am in the last 24 hours? It's a collaborative process. It has to be collaborative in order to work. It has to be honest, and it has to be trustworthy. So I think the challenges that are out there are all, I have identified some. But I think all of the challenges can be addressed because they have been addressed in other areas like medicine. So how do you address them? How do you make a safe place? Well, that might have something to do with when you conduct, at what point you interject the Sentinel event review. But in medicine, there's been legislative protections enacted for people who participate in these Sentinel event reviews, so that what they say isn't discoverable in litigation. Hey, if that's my wife. There are protections, for instance, for doctors that participate in a Sentinel event review after a surgery that's gone bad. Even if they work for a public hospital, the documents and the notes from those meetings are not subject to disclosure under FOIA laws. So that would be a significant kind of barrier to give officers and others involved in the process a safe place to go to actually be open and review exactly what happened. And I know I'm probably getting short on time. I hope I'm not cutting into anybody else, but I wanted to raise one other issue that we've talked. Am I okay?
Go for it.
Okay. How many of you are familiar with the phrase heater case? A heater case. Oh, wow. Okay, not that many. Well, this is cool. So in a lot of police departments, cases of notoriety are commonly referred to as heater cases, and those would be cases where, because of the nature of the crime or who the victim is or who's accused of committing the crime, maybe the city government's leaders or the department leaders, press and or community leaders have a strong interest in the investigation and its outcome. So like examples might be a serial murder case or a serial rape case or a case where a child is the victim. Things that really draw a lot of public attention would be heater cases. Heater cases get a lot of extra attention and a lot of extra scrutiny, not only from the media and from the public, but like within the organizations. And I think because of these cases, because of those factors, these cases remain in the spotlight unless they are solved or until they are solved. And the pressure on line officers and detectives in these cases is incredibly immense. And so I like to talk about something called stopping the line. And this is something that occurs in manufacturing. In fact, there's Harley Davidson, happen to be a Harley guy myself. Harley Davidson actually has negotiated, its employees have negotiated in their contract an individual right for employees who work on the assembly line at the Harley Davidson plant. If they see something that they don't like, they can stop the line and there will be no adverse employment action taken against them by the company. So they can halt production. If they see a screw that's loose, if they see something that doesn't look right, they can stop the production line. We don't have a mechanism like that in law enforcement within police departments. In fact, stopping the line particularly, and I mentioned this in the context of a heater case, because I think those are the times when we need to have a stop rope or a kill switch, or bad metaphor, a way to stop everything and say, wait a second, I just saw something that wasn't right. And it doesn't matter at Harley if you're just the person that puts the rivet in the one piece of the engine. If you see something wrong with the fender, you can stop the line. And there should be a mechanism in place, particularly when we're talking about instances. I mean, I guess I don't need to justify it to this group, but look at the exonerees that are in the room. Somebody somewhere along the line in those cases could have pulled the rope and said, wait a second. The only two witnesses in this case have their own agenda here. What have we done to verify what they're saying? And for whatever reason, nobody stopped the line, and the results speak for themselves. So I think there's a lot of good news. I picked up a lot of good news at yesterday and today. Technology is constantly evolving. Somebody yesterday said, tape everything. In Illinois, many of you probably know, we've put some fairly stringent video recording requirements, particularly in capital and cases of Class 1 and Class X felonies, where the entire time, basically, if you're going to interview a suspect, that camera's got to be on the time they walk in the door, and it doesn't go off until they walk out the door. We're doing a lot of those things, but I'm really excited about other technologies because like Taser has developed this Axon camera program, which a lot of departments are seeing around the country, where every interaction between police and members of the public can be recorded. And, so we're quickly approaching that time. And finally, I'm really happy to see the new generation of police officers that's coming into the profession now, who are unlike any other generation, willing to kind of shake off the traditions and are really open to new things. So I wanted to end on a high note and looking forward to seeing what happens in these 3 jurisdictions where we've got things. Thank you.
Thank you so much, Sean. I know you raised several issues that we're really looking forward to tackling in the beta project. The creation of a safe space for this type of review to occur is absolutely essential. How best to communicate that safe space exists and have people trust that it actually is a safe space it's absolutely a priority for us moving forward. I know I said, John, that you would be next, but I'd like to switch it up and actually go to Maddie next because if I recall, you also have some thoughts on Stop the Line, not to put you on the spot, but if you wouldn't mind addressing Sean's Stop the Line proposal as well as addressing SEI in approximately 3 minutes.
I thought Sean was setting me up with the Harley analogy.
You're welcome to go back to it.
Okay, so you want me to go
yes,
next?
about 10
Okay.
minutes. Thank you.
Yeah, stopping the line's a good thing and a really hard thing to allow, people to do because there is a lot of conformity in every workplace. And it's true at the Innocence Project, and I'm sure it's true in the police departments, and it's true everywhere. It's hard to be the person that says, I don't agree with what becomes the common myth or the common culture. So I think how you create that is incredibly important, and maybe the Sentinel Events process will allow people to see in a structured way that there is in fact an opportunity for that, and that questioning everybody's implicit assumptions is in fact a legitimate and an applauded activity. And I think that's also about leadership in departments all over the place, is really saying to the person who steps forward and says something's not exactly right, thank God you said it, we appreciate it, and that gets rewarded rather than punished or shunned. So that's a challenge. I wanted to do 2 things in the minutes I'm given. And that is, one, to talk a little bit about what wrongful conviction review panels have done, because we know that there have been a number of states who have engaged in reviewing wrongful convictions over the last really 10 years, and there probably are states I don't know of, but I know that there have been 11 sort of states that have engaged in official innocence commissions. Some of those commissions look mostly at policies and sort of accept before they walk in the door what the major leading causes of wrongful conviction are and begin to address the reforms. And you've heard about some of those areas today: informants, eyewitness identification procedures, false confessions. But others start, as Pennsylvania and Oklahoma did, and as the New York State Bar Association Task Force did, with looking at the individual wrongful convictions in the jurisdiction that were known, often proved by DNA, but more and more by other kinds of techniques and evidence. And as a result of those, so I start in sort of a good place, there have been reforms, I think that are moving across the country, recording interrogations in almost half the states, blind administration of eyewitness procedures now in 8 or 9 states, and probably on eyewitness in 30% of the major cities, maybe the largest 65 or whatever they are that are major city chiefs right now. There is blind administration of lineup procedures or photo arrays. There's increased vetting of informants and this issue of reliability and what is it when only 2 witnesses, both of whom had something to gain, are used there. And I think states are adopting and localities are adopting procedures. I think there's a growing understanding from the evaluation of these cases, both at the state level and nationally, of the understanding of the frailties of forensic disciplines. And there is a growing understanding that this is not about blaming people for the most part, being bad people who want to do the wrong thing, but in fact that there are significant psychological cognitive processes that, make it easier for us all to do our jobs if we have a theory and we stick to it. That's a lot easier than changing your mind every 5 seconds about maybe you're wrong and doubting yourself. So there's these issues, this growing understanding of these cognitive biases and an understanding about ways that we can fix the system to sort of work against those. And the IACP has really done amazing work by pulling together leaders from across the country and looking at these disciplines. So I think some things are being done. What's the challenge of some of these wrongful conviction review panels, and I think what the Sentinel Events program that NIJ is proposing, and I'm sure at some level some people do in parts of the country that we may not be aware of, and maybe we'll hear about some of those if there's time for questions, is in the area of wrongful convictions, one of the great challenges we have is that a lot of time has passed. So you're looking at incomplete, and the records weren't kept well at the first place. So years later, 13 on average we hear, but as many as 30, you can't really tell entirely what went on, but certainly we know a fair amount and practices have changed. So a challenge is the time and the records. I think the context in the wrongful convictions, these are really bad outcomes. And there's a lot of unwillingness, I think, for all the actors to look back and say, did I contribute? How did I contribute? As Jim suggested, I must have in some way contributed to this, but there's an instant inclination to find something that somebody else that did that was wrong. And the context, by the time the person's been tried and convicted and lost appeals, is an adversarial context. So it's not at the beginning when maybe it was just fact-finding and fact-gathering, but a lot of years of adversarial process has gone on. So that to enter that inquiry after, a decade or two of litigation, if you count the initial rounds and then the post-conviction rounds, it's a hard place to then throw away your adversarial hats and just kind of sit in a room and try to understand, although I think these commissions have really tried to do that. And there's the potential for liability that comes to the jurisdiction, perhaps to the defense attorneys, and to the municipalities in these cases that make it hard for people to admit error. I have talked to law enforcement people who have been involved or in jurisdictions where the wrongful convictions happen, and I've been told by people that they were instructed by the city lawyers to not say they were sorry, to not admit that there was a mistake, and maybe not even to admit that there had been a real wrongful conviction out of fear of the civil implications or the implications that would flow from that. And as long as you have all of that going on, it's going to be very, very hard to create a safe space. So there are challenges. I think as people think about these Sentinel event reviews, there are lessons, and we've heard a lot of them over the last few days. I mean, finding, at least as you start, kind of timely incidents is one thing that may be very helpful, just so memories are fresh and the records perhaps are more, can be found. To review errors or outcomes that everybody agrees are bad. I mean, that's the great thing about a wrongful conviction. Once everybody agrees it happens, is that nobody thinks it was a good outcome. Everybody agrees it's a horrendous outcome. But to find incidents for these reviews where there's absolute agreement that the outcome is bad. I guess the other thing is a commitment, and we've seen it in these multi-stakeholder panels, and we're hearing about it today, a belief that everybody in the room, everybody really does contribute an important perspective. I think this notion of collaboration, that the police have something to say, the family has something to say, the prosecutors have something to say, the defense attorneys have something to say, the judges have something to say, and to really get out of the mode that thanks very much, you've given us the evidence, now we'll go ahead and we'll take care of it and we'll figure out what we really got here. Or we're the defense attorney, we're not that interested in all this other stuff that you have. We think we have the perspective into it. Is to really believe that together we work in these systems and can solve it. And I think that, we've seen it in the wrongful conviction context, and I'll just for a moment share an experience I had in another part of the criminal justice system. 25 to 30 years ago, I worked in the New York City jails. and I worked as a health administrator, and I worked as an oversight person, and we had a process that was a sentinel events process. It was deaths in custody. Every time there was a death in custody, either a suicide, not the homicide, so I appreciate those came out and were in a different process, but every time there was a suicide or a death in the jail rather than a death in the hospital from somebody who was ill, we had multi-stakeholder reviews that people came together. The mental health people and the healthcare professionals, the correctional officers, the correctional administration, the mayor's office convened those meetings, the Board of Correction, which was an oversight agency for the city jail, staffed those meetings, and folks came together pretty quickly, within 6 months, usually after a death, to really look, what did everyone think happened? What did somebody like the Board of Correction that came in and sort of looked at all parts think happened? Can we have a discussion, because everyone agreed that a death in custody was an unacceptable outcome? And how could we, in fact, do something to make it better? And I think and things happened. We changed policy in the city jails. We added additional posts sometimes to housing areas where, in fact, the officer couldn't possibly see what was going on from the post that they had been given. Or we added screenings in the intake evaluation of people to make sure that appropriate mental health questions were asked. And other things changed. Prisoners were trained to be additional eyes and ears to walk in the facility and make sure that people who were exhibiting unusual behavior or were particularly tearful, who had gotten off of terrible phone calls, would somehow have somebody who could continue to watch them in the case of suicide prevention. So we really saw things that changed. And what were those elements that made it successful? I think they were the sorts of things that we've heard today, and that I've said a little bit about the wrongful convictions. We all agreed that the outcome was bad. The incidents were relatively fresh in our mind. There was a protection in the room. The discussions in that room were not discoverable. They didn't go out. There were certainly parallel processes that continued to happen. People were sued for suicides in jails or bad outcomes, deaths in custody. But the deliberations to try to fix the policies were sort of protected so that people really felt that they had an open space. The other thing about those committees is that they, in fact, were staffed. I think that police departments, public defenders, prosecution offices, everybody is very, very busy. And even if it's very important, if what you're supposed to do in the course of doing your work is to stop to look at something that you've already done, bad or good, it's hard to get people to stop. So I really advocate, as people think about how to do these reviews, to make sure that you have designated someone or some group of people whose job it is to do this. If it's not someone's job to help staff these reviews, I think they can't be incorporated into the work that you do, because there will never be time to get to it. So I think we've seen it happen in some contexts. I've participated in processes that I think really worked and produced change. And I think you've heard lots of good examples of ways of protecting the process and staffing the process. And so it will be great to return when the Quattrone Center sponsors 5 years from now the what have we learned, what have we done, and how is it working in criminal justice, to hear how it's working in criminal justice. So thank you.
Thank you so much, Maddie. All right, John, you're up.
I just think this is a really, really exciting time to be in the criminal justice field. I say that because I imagine that the people who were working on reduction of unintentional deaths in the hospital system had that same feeling while they were doing it. In other words, I'm sure that a lot of hard work went into trying to assemble people that were looking at the data, looking at the research, coming together and talking to one another. But it probably took a long time before it really gelled. I talked with Joe McCannon, who actually came to Milwaukee. He was intimately involved in working on that process. And they set out with a very specific goal. They said, let's reduce unintended deaths in hospitals by 100,000. That's our goal right there. And they exceeded it. And they exceeded by doing many of the steps that we've talked about. I'm sure that in the air safety transportation business, the same thing was occurring. I am sensing in my work, both in Wisconsin and with DAs from around the country, that there's that same sense. And it goes back to a sense that we can do better. We can do better as a system. Certainly as prosecutors we can. This whole discussion ironically brings me back about 25 years. I think of my time in service. I was a young second lieutenant in Korea, and a quote has always stuck with me from another famous Philadelphian. It's not Ben Franklin. It was Jeff Jarkowski. Jeff Jarkowski was my company commander. He was a Philadelphia guy, and after an operation, we did what we always did. What we were required to do is we had an after-action review. That was a policy implemented by the military because of the failures post-Vietnam, during Vietnam and post-Vietnam, where they had identified that the system lied to itself to protect itself. And so what the leadership insisted upon was a system where leaders developed other leaders to speak honestly to themselves and to be self-critical and to learn from their mistakes at all phases, particularly in training. So as a young lieutenant, I was in an operation and we had a brutal after-action review where you were required to say, what's the mission? What did we do well? You could spend maybe a minute saying what you did well, and then the remaining 59 minutes were spent beating yourself up and identifying the things that had gone wrong, parts of the system that hadn't interoperated, and all those different things. And the purpose, and so I was feeling horrible about it, and Jeff came up to me and said, hey, keep in mind, when the bullets start flying, it's not the best side that's going to win. It's the least screwed up side that's going to win. And you have to keep that in mind. What he was just basically telling me as a young person is, look, there is no perfect system. Yeah, you can learn from all of these things. The Army had the best field manuals in the world that nobody ever read. And the reality was if you listened to outside experts and you did more than just listen to them, you actually incorporated. What I think is unique about what's going on right now, certainly is reflected through the NIJ process, but it's also reflected in other efforts that are taking place around the country, is for the first time, I think the criminal justice system is opening up and saying, you know, we're not really good at this. We do have to work with experts in the field of research, and we have to open up to experts in the field of public health. And we have to work with them and incorporate their experiences into our experiences, because we are not based on the scientific method. We're an adversarial system, and we have to redesign our system, quite frankly, to keep the best aspects of the adversarial system, but to open up avenues to change things. Most fundamentally, I would argue that you have to change the relationship between public defenders, defense bar, and prosecutors early on in the system. Many of these mistakes that occur in the system would not occur if there was an open sharing of information and an exchange of thought early on in this process. The same thing is true with working with police officers and developing a level of respect. And I go beyond that. You have to elevate other parts of the system to co-equal status. You have to look on pretrial service people as having something to say about who comes in the system and who doesn't. You have to elevate your public health advisors, and you have to elevate the researchers you work with to co-equal status. They're not just afterthoughts, they're not just nice appendages. So with this project right here, we do have one advantage in Milwaukee. We've been working with a wonderful person, Dr. Mallory O'Brien, with the Homicide Review Commission, and we started this in the early 2000s, where we really examined every homicide that has occurred in Milwaukee since 2003, and we've brought all the partners in the system, both in the social services and law enforcement and the court system, children's court system, and we just examine every homicide that occurs and break it down and figure out what could have been done to prevent that. But that process has been focused on just one aspect. I think the potential exists with with the Sentinel Review Project is develop a template and then apply it across the board. You find the things that you think could be causing problems, develop your template, and then whatever it is, execute it. Develop a team and execute it. Then I think you're going to see a more systemic change. So as opposed to programmatic or therapeutic change, what you're ideally looking for, in my view, is systemic change. And of course, since we're challenged by the fact that there's 3,200 different counties throughout the country, if you can develop some models that people see actually work, and then you get people like myself who are prosecutors, and prosecutors are generally some of the most risk-averse people in the system. If you can get people like myself to say that not only is it effective, but it makes a significant difference in areas that you might not anticipate, which is making your community safer, but even more than that, involving your community in the solution to these problems. What we're talking about when you're talking about integrity cases and innocence cases, it's really the basic trust that the community has in that system. And we have every bit as much of an obligation to be in the front of addressing those issues as anybody else. If you maintain that trust with the community, then you can really start changing what's taking place in real neighborhoods over a period of time. And that's, again, why I think this is just an exciting time to be there. I would also argue in closing that it's really just the start. That working with public health professionals, medical professionals. I think the fascinating time right now is that I think we are really on the cusp of being able to identify our most at-risk populations across a whole spectrum of challenges from the time that they are born, when they're entering their education phases, to when they start entering the criminal justice system, the child neglect system, and then identifying the factors that are most likely to lead to repeat contact with the system. And the better we get at identifying those factors and addressing them before they encounter a police officer, I think that's the promise of the future. But it's only possible because of our willingness to start working with people in the public health field and in the education field. So it's an honor to be here, and I hope to continue working with you for a long time.
I want to say thank you so much to our panelists. It's very clear that we all have our work cut out for us in the beta sites, but I'm heartened to hear that you at least think that there's hope and have shared some sort of measures of success, and we're just going to keep on plugging along and calling you up to speak about this many more times in the future. Is it safe to say we have one question? Okay, the first question is going to be from Rick Walker.
Thank you. My name is Rick Walker. I spent 12 and a half years in prison for a crime I did not commit, and I was exonerated in 2003. And I just have a couple of things that I want to say to this panel and to everybody. First and foremost, I want to thank Frank and Denise. Frank and Denise are part of the Northern California Innocence Project, which I'm a part of as well. This is my family. And thanking John for having us all here today. And what I want to say is the problem that, something that's deep inside of me is about the district attorney's office is based on wins and losses. And I've asked several people over this decade that I've been out of prison, I got out in 2003, that if a district attorney loses every case, but the right outcome it comes out of that case, how long will he have his job? Right? And for the longest, it's been based on wins and losses, and it's a big game. They bet a nickel. The district attorney and one of his cohorts bet a nickel on my case. One said, you don't even have a case against Walker. You won't win. And they bet a nickel. And my father happened to be in the elevator when that payoff took place. Right? And I just want to say that these deals that they make, it's just unconscionable. What they do behind closed doors in these matters. And There was a letter, evidence, and this is something, there was a letter that the actual perpetrator in this crime was arrested and had a deal. He got a deal in this case. And he signed a letter in his blood that I gave you Walker and now I want my deal and da-da-da-da, right? Well, this letter by the sheriff's department was placed in the file, but it wasn't included in evidence. And with that, we discovered this letter after I was out. And when they were queried about why this letter wasn't included, they said, well, we didn't think it had any real evidence. I mean, it had any real value in the case, right? And so things like this happen, right? And Maddie said it about the apology. My attorneys told me, my civil attorneys told me, Rick, they'll never apologize, right? And I'm like, really? They'll never apologize. The only way we can make them apologize is with their wallets. And Maddie said it. They are told not to say anything because it might enhance this civil issue, right? And so then you get the outlook that this is all about money. They took my life, and now it's all about money, right? And so, and he was absolutely right. They wouldn't apologize. And the district attorney, who actually said, George Kennedy, I can't exactly quote what George Kennedy said, but basically he said, in his 20 years as district attorney, by far the worst thing that ever happened to him was the Rick Walker case. Right? And I thought that was a great statement, that he actually said that. But then county council told him to shut his mouth. Shut his mouth. We still have a civil thing going on here. Shut up. And that's what they told him, right? And so, yeah, I think until they can be transparent and actually admit that they made a mistake, that we got a real long way to go here, a long way to go. This is one of the best places I've been so far, and I think we're in the right direction. I really, really think we're in the right direction. Frank and Denise, I don't know who came up with the idea of fair administration of justice, but that's what we need. We really need it to be fair across the board, and it's not, right? And if I had to count on one hand the number of people that have apologized to me in law enforcement or from the district attorney's office, it looked like I'd be pointing my finger. I like to thank Sean, because Sean stepped forward and said on behalf of the police department, I want to apologize to you today. I do. And I think that's a step in the right direction as well. Accountability is what we need. We need people to be accountable for their actions. In all that went wrong in my case, Rick Tulsky did a 5-day editorial that was 10 pages long about tainted trials and stolen justice. On the second day of this editorial, it was 10 pages long and it ran 5 days. Rick calls me up on the phone. He says, Rick, I want to apologize to you. I go, what for? He goes, because I couldn't base the entire editorial on you. Out of the 15 factors that I used to show about prosecutorial misconduct, snitch testimony, all these things, this whole list that he had, he says, every single one of them happened in your case. But I want you to know that the reason I'm doing this here, it was based on your case and a lot of other factors, but it was based on I used your case as an example. And now Santa Clara County District Attorney's Office wants me to come in and sign some documents so that they can use my case as what not to do in a courtroom. But I really think we're in the right direction right now. But the thing that I need people to do is be accountable for their actions, right? Individually and collectively. Thank you.
Rick, thank you so much for sharing your story. And I will say that I'm heartened to hear you say that you think we're at least going in the right direction. I think sort of the theory of change behind the Sentinel Events Initiative is that you don't just deserve an apology from the DA, you deserve apology from the system that failed you. And that's the type of review that we're hoping to conduct. So thank you. Next question.
Yes. My name is Chuck Ruder. I'm the police chief, been a police chief for over 40 years. I appreciate everything that's being said here, but I'm really focused on how we are going to change our system. And I come from a very particularized part of the system, the front end of it. But I'm looking down at everything that has to be done. And listening to Jim and Sean and John and Manny, listening to all the other parts in this, we're looking to say, how are we going to have blame-free workforce that will come forward and, Sean says, pull the stop button, and at the same time have some accountability for the behaviors that occur in our system. So when you look at the processes and say the processes are wrong, and our policies and our practices and training and all the rest of the stuff might not be working, but what are we doing about misconduct within our own systems? I mean, there are corrupt judges, there are corrupt lawyers, there are corrupt cops. And unless we're going to do something about that corruption, and unless we're going to identify that misconduct and call the misconduct what it is, we're never going to be able to get to a blame-free organizational system that will allow people to feel that they can come forward. And then you got to take the politics out of it too, but that's another one.
Well, I think that's exactly right, and that's the hard discussion right there, and that is it's great to talk about system improvement and collaboration and learning from past mistakes, but you still have the obligation to meet exigent demands. That means that no one stops calling 911 for you to redesign your system. You still have to have police officers responding to the very legitimate needs of the community every day. The police department has to do the same thing. One approach to it, though, can mirror what we're talking about here. And, if you create a public integrity unit that is cross-jurisdictional and is trusted to take on those complicated issues like police misconduct, like prosecutorial, like attorney misconduct, or public office misconduct. Those are by and far the least popular, most difficult, complicated cases. But if you develop some expertise and develop some credibility with those organizations, I don't say it with pride, but the office has had to prosecute over 100 law enforcement officers in the last 10 years in Milwaukee County. That's like I said, those are difficult cases, and it's we've prosecuted a significant number of public officials. We've prosecuted attorneys, and we've had high-profile prosecutors prosecuted for misconduct as well. So that's part of it. I mean, that's, to have integrity in the system, you have to show that the system holds itself accountable. I don't want to hold our system out as being the model of that, because there isn't any such thing as a model of that. You have to just take that battle on each and every day. But I think there are systems similar to what we're talking about here that could be developed and scaled to different types of jurisdiction depending on their size. But I think it has to be done on sort of a task force model.
So I apologize. I think we're probably only going to have time for one more question. But
Yeah. I'm really glad you just said that, John, and virtually everything you said. I wanted to try to point out just a few things from yesterday. One of the things that Linda from Connell, is Linda still here? I think she's gone. Oh, there you are. That she was pointing out about her reviews that I thought was very interesting in these kind of all stakeholders reviews as to the people that reviewed, how many did you say, 90,000 that were themselves the experts who could hear from what John was saying. You want to hear from the people at pretrial services. You want to elevate everybody that's involved in the process. which, by the way, is one of the main messages of the checklist manifesto and so much that came out of To Err is Human in terms of looking at the teams and trying to learn from it. But I was fascinated that somebody that had a sense of the whole system was listening to each one of those complaints, because that in turn you'll be able to pick up maybe the really good idea. So that was, and it really goes with Maddie, you have to get a record of it and somebody that staffs it and makes clear what's going on. So that was one thing. And the second thing, and this really comes from suing. The truth of the matter is Peter Neufeld and I have learned as much about wrongful convictions and remedies from having done civil suits, because until we did the civil suits, we never fully understood everything. I mean, we deposed everybody, and that, makes all the difference. And by the way, it only enhanced our appreciation for the role of the police and the needs, because they're the only people we can sue. We can't sue the prosecutors, generally speaking. They have absolute immunity. We always count on them to say that they never knew about the Brady material, even if we think they did, and they often do that, to help the lawsuits go forward. But looking at that, we've learned a lot about remedies, and it's not just in wrongful conviction cases. I don't see David Radofsky here today, but in lots of these other kinds of civil cases. And when you really begin to look at remedies, that's where people like Sean are the greatest allies. Because there's a lawyer in Cincinnati named Alka Hartstein that Sean and I were talking about last night, who is just brilliant at this. He helped solve a lot of these problems in Cincinnati, and he always brought the police union in, as well as the police officials and the line officers, in order to come up with a remedy that everybody could buy into and believe would work for them. In terms of stop and frisk, in terms of all kinds of things which you can reimagine as or rethink as officer safety issues, officer mental health issues. So in terms of putting together these Sentinel reviews, I'm really fascinated to see how the beta sites work. I'm not one of those that we've always loved this idea. I'm not one of those who wants to see it fail and wants to say it can't be implemented. But I don't think it's too soon to take that same model and have it looked at in district attorney's offices and in public defender offices. I mean, after all, if you want a protected space, both groups have absolute immunity. There's no reason you can't bring people in, and maybe some of the ones like the police who don't have absolute immunity, and have a discussion, a frank discussion, to review something that looks like a total system failure, or, I don't know, a near miss. I should call it an averted mistake. But to bring everybody in to discuss that in both offices. And indeed, the notion of conviction integrity units, it has two parts. One is investigating wrongful convictions, but the other part are the use of checklists or the use of learning from error. And really, it should, I think, personally, should really embrace a Sentinel review approach to those kinds of discussions, and then we'll learn a lot. So that's the protected space. The cops always get the bad end of the stick, I'm afraid.
We're used to it.
Thank you for that. Jim, I'm going to ask 30 seconds. We're already over time. Just to respond to the second point about bringing that type of review into a secure, protected space like a prosecutor's office or defense attorney's office.
Well, I think the point is the best way would be a space where more and more people are involved, where it's not just the prosecutors, it's not just the defenders, it's the police, it's the exonerees, it's the victims, forensic science people, crime scene experts, everyone involved. So I certainly don't have anything against prosecutors talking to defenders, but I think there's a little question about when you limit the whole thing to this adjudicatory group who are really just involved with the inspection of the output rather than with reforming the processes leading up to the output.
I wasn't suggesting that. I was suggesting that all stakeholders, but I'm saying the conveners of it, right?
I think one of the things that I think we're going to begin to find out from the beta sites, and if demonstration projects follow, is who is a good convener here? Is it the city attorney who, unlike the one in Rick's case, will learn that risk of future lawsuits is more important than dealing with this particular case that happens to be under my nose right now? Would it be the local judiciary? Would it be a local criminal justice entity like the Quattrone Center? That will make a difference in terms of what's discoverable, what can be produced. So I think the question would be, let's let localities work on this. Let's see what works locally in particular places. I also think there are probably different ways to do things depending on what sort of event you're talking about. Are you talking about the wrongful release of somebody who goes out and hurts someone? Are you talking about a wrongful conviction of someone who's locked up for 20 years while the real guy goes out and hurts someone? Are you talking about a near-miss event where things are intercepted before things happen? All of these things, I think, are ripe for some experimentation to see what happens. I think the key things to keep in mind are another lesson from the medical world, where when you find one of these things, the mantra of Donald Berwick and the other pioneers was every defect a treasure. When you find one of these things, you can learn a tremendous amount from them if you look at them, if you understand that all the individuals involved are responsible for the collective outcome, and if you start to pivot and create for yourself something that the criminal justice system doesn't really have, a kind of forward-looking accountability that doesn't just say what happened wrong here, but what does it imply for what we might do again if we don't address the root causes of it. A way to look at processes. In general, we have a big, revered adversary tradition of inspecting outcomes, but we have a very undeveloped capacity to look at processes. And I think the lesson of the last day, among others, was you have to learn to find a way to look at processes, and that's sort of what this Sentinel event thing is meant to do. Give the good guys in the system something to do other than hunt down and punish the bad guys. Doesn't mean you stop doing that, but you do this too.
I guess just the one quick thing I want to add on the medical side, something else we learned, was that in medicine there have been studies that have said that apology and honesty by practitioners about failures and mistakes actually reduce civil litigation, malpractice insurance, and allow for a process of moving forward. So I think it's for Rick, for Frankie, for Michael, for others, it's a good lesson for the criminal justice system to learn. There's a benefit to just being sorry.
Thank you so much. I think John's about to take our mics away, so we should. Okay. Thank you.